Welcome to this training tutorial on copyright protection of software and digital preservation, created by Barbara Colony-Reiser and Elena Marks, and brought to you by the Timbus Project. This training video, broken into two segments, will provide guidance on how copyright protection of software will impact digital preservation. In order to gain a general understanding of the topic of copyright protection of software and digital preservation, consider the following use case. A pharmaceutical company buys software from a software development company. The two companies sign a license contract in which the software development company grants the rights to use the software for day-to-day business. This software plays a crucial role for the pharmaceutical company. Therefore, when the pharmaceutical company wants to digitally preserve their business processes, this software also must be digitally preserved in the digital preservation system. European law allows the pharmaceutical company to make a backup copy of the software and to store this backup copy in their digital preservation system. However, this may not be enough to ensure the future reactivation and redeployment of the business process, because reactivation and redeployment require processes like alteration, migration, porting, and emulation, in addition to reproduction, to allow for future changes in formats and standards. All rights within the software originally belong to the software development company. In the license contract, the software development company, as rights holder, may grant the necessary rights of use for day-to-day business. When the pharmaceutical company needs to undertake additional actions as part of the digital preservation process, like alteration, migration, emulation, or porting, which are not explicitly granted in the software license contract, they risk infringing the exclusive rights of the rights holder. Therefore, the best solution would be for the pharmaceutical company to negotiate an extension to the license contract with the software development company in order to carry out digital preservation without infringing intellectual property rights. When the software development company provides the pharmaceutical company with a piece of software, they are providing a computer program, an entity protected by copyright according to the Computer Program Directive. In order to establish the circumstances under which a computer program enjoys copyright protection, we must first determine the term computer program. Surprisingly, the Computer Program Directive does not define the term. However, Recital 7 of the Computer Program Directive provides the underlying idea. Recital 7 specifies that any form of computer program, even those included in hardware, are protected. Moreover, any preparatory work from which a computer program may result at a later stage is also protected. This rather abstract definition indicates that the legislator deliberately refrained from creating an explicit definition of a computer program. As the needs for digital preservation suggests, technical changes occur quickly, as do programming technologies that demand instant reactions and adaptations. The lack of an explicit definition of computer program allows the Computer Program Directive to subsume future programs, while any definition would have quickly become obsolete. Nonetheless, a number of resources provide useful definitions that help give an idea what is covered by the term. The DIN 44300, TL4 number 419, for instance, defines software as a complete operating procedure for the solution of a task. The Computer Program Directive provides for the copyright protection of computer programs that meet the requirements set out in the legislation. Software as a computer program will be protected if it expresses the minimum characteristics of intellectual creation. The form of the program will not affect whether or not it will be protected. Therefore, all the various representations of the program, such as the data flow diagram, the object, and the source code, are all protected. However, copyright does not protect the idea or concept underlying the program, but only the particular manifestation of that idea or concept. Thus, the programming language used to write the program is not covered by this protection. It is important that the software user, in this case the pharmaceutical company, knows the identity of the author of a computer program. because the author owns the exclusive rights and holds the authority to grant the rights of use necessary for digital preservation. The author is the creator of the program, and the creator can be either one person or a group of individuals. In the instance of a computer program having more than one creator, all creators must consent to the rights of use requested by the software user. A legal person can own the copyright as well, if permitted by the legislation of their member state. If an employee creates a program while in the progress of his or her work, the employer is entitled to exercise all economic rights unless otherwise provided by the employment contract. In the case of an employee creating a program, the employee maintains the status of author of the computer program, but the employer owns the copyright in regards to all economic rights. The purpose of digital preservation is twofold. On the one hand, digital preservation aims to maintain long-term access to the data substance. On the other hand, digital preservation aims to maintain the operability of the computer programs, external services, and business processes. In the example case of the pharmaceutical company, digital preservation of the software program enables the company to secure their investment in that software. However, because the software program was developed by the software development company, the pharmaceutical company must obtain further permission to do so. In other words, the preservation of the software amounts to the preservation of third-party material and requires the necessary rights of use granted in a license contract. The multiple processes necessary to preserve software makes the digital preservation of a business process very complex. Four main actions relevant to business process preservation, however, give a general picture of the necessary steps. First, a company cannot archive a business process along with the current software in use without disrupting the business process. Therefore, the company must inevitably make a copy of the software in order to archive the process. Making a copy is an act of reproduction, which is the core exclusive right held by the software developer. Article 4 of the Computer Program Directive establishes restricted acts and entitles the rights holder to prohibit anyone from reproducing the work. Article 4(1)(a) of the Computer Program Directive outlines these restrictions. Permanent and temporary reproduction by any means in any form, in part or in whole, insofar as loading, displaying, running, transmitting, or storing on the computer program necessitates such reproduction, requires the authorization of the rights holder. However, the Computer Program Directive also contains limitations to the exclusive rights of the rights holder. Article 5(2)(a) of the Computer Program Directive establishes that the making of a backup copy by a person who holds the right to use the computer program may not be prevented by contract insofar as it is necessary for that use. The storage of a copy in the digital preservation system is possible without an infringement of copyright when the copy is made by a person who holds the right to use the computer program. This person is called a lawful acquirer. A backup copy is a copy of the sold or licensed program in its original form. The backup copy cannot be used for the daily use of the program, or the backup copy is necessary to ensure continued use of the software. However, no changes can be made to the software backup copies. Changing the backup would amount to an alteration, which is not covered by this exception. Furthermore, a company must prove that one copy is insufficient and can only ever make a few copies. Second, digital preservation often requires migration. Migration entails moving a software system from its initial environment into a new environment without changing the functional properties. Environment includes hardware, operating system, applications, and tools necessary to run the software within its original environment. To migrate software into a new environment, the two systems have to be compatible. In other words, the new environment must perform the same tasks as the former environment. Migration preserves the functionality of digital objects and enables the licensee to retrieve, display, and continue to use the objects through future technological advancements. Thus, migration consists of an active adaptation and an active alteration. Again, these two rights belong exclusively to the author. Therefore, the software user must obtain a license to the required right of use to migrate the computer program. Porting offers yet another way to preserve the operability of a complete software process. Porting entails the transfer of an application so that it will function on a new platform. Depending on the type of software, the source, and the target platform, the porting process can involve many different actions and, as a result, impact different exclusive rights. Usually, porting risks infringing the right to adapt and, as with archiving, the right to reproduce if permission is not granted. Furthermore, digital preservation often relies on emulation. In contrast to migration and porting, emulation does not focus on the digital object, but on the environment in which the original object was created. Emulation entails recreating the original environment in which the digital object was created, allowing the use and execution of the original digital object without altering the digital object itself. Emulation risks infringement of the exclusive intellectual property rights of the software developer only when it requires the alteration of the preserved data. Only when the user needs to alter the digital object will the user need to obtain consent from the rights holder in order to prevent copyright infringement. When emulation of the environment is possible without an alteration of the stored data, the reuse of this data has no effect on copyright law. The necessity of an alteration of the preserved data during emulation must be assessed on a case-by-case basis. This is the end of part 1 of this training video. Please watch part 2 to continue this tutorial.